Good day. I'm Jerry Mason, legal counsel for the Association of Idaho Cities. I'm joining you today to discuss the purchasing of services by cities in Idaho. I would encourage you, if you have any questions regarding this topic, to click on the link above the screen here on the webpage and send your question our way, and we will do our best to answer it on the webpage in future days. The purchase of services for Idaho cities is an important function, and it's governed by the consolidated purchasing provisions found in Idaho Code Title 67, Chapter 28. Chapter 28 was developed by a working group of political subdivisions in order to develop a standardized way of purchasing for all units of local government. The purchasing of services is generally governed by provisions of Idaho Code 67-2807. Although some of the procedures are similar to those employed for purchase of public works construction or personal property, there are some differences that are worthy of note. Different types of services require different procedures to be followed. Additionally, specifications are often the key to success for the procurement of services. For purposes of this discussion, we will divide the service purchasing into three general types. General services, whereby the services can be described in specifications and could be performed by anyone with basic skills. Personal services, where the service provision is based upon distinguishable qualifications that a service provider might have. Professional services are those provided by licensed professionals, traditionally known as the learned professions. What distinguishes the latter two from the procurement of general services is that the former must be purchased, if it is bid, based upon the lowest price. Personal and professional services do not. General services include things like janitorial services, landscape maintenance, or street or parking lot sweeping, just by way of example. For most services, the procedures are very similar to those applicable to personal property purchases. Another video training regarding personal property purchasing is available on this website. General services that are bid are subject to procurement at the lowest price available, so long as the bidder meets the requirements set forth in the specifications and the bid process. For purchases less than $25,000, be sure that the costs of services are aggregated based upon a year of service. The purchase can be made for what the city believes to be the best value if it is below $25,000. It need not be the absolute least priced, but a value judgment can be made about the quality of the service available. For those services that reach a cost level during any year of between $25,000 and $50,000, the semi-formal bidding process must be employed. Though the semi-formal bidding process provides a full description of services, it can be done in a semi-informal way. The notice must be sent in writing to bidders and give them an opportunity to review the specifications and to object to any bid specification at least one day before bids are due. When the bids are received, they can be checked for qualification, but in the end, the lowest qualifying price must be accepted. When general services are to be performed during any year that exceed the $50,000 cost threshold, the procedures to be followed must mirror those for competitive bidding for public works construction. Notice must be published in the city's official newspaper according to statute. Opportunities for objections to specifications must be provided, and sealed bids must be submitted. Once again, the lowest price by a qualified bidder must be accepted. For any agency purchasing services, the key to protection must be well-written specifications, often including a prototype of the contract that will be expected to be entered into. Thorough staff work before bids are open can save substantial pain and suffering after bids are on the table. One principle to remember is that controversies over specifications or performance terms are always best resolved before bids are received and open. Once bids have been received, bidders suspect that any decision involving such controversy is motivated by a desire to favor one bidder over another. Always work with your city attorney regarding bidding controversies, both before the bids are open and after. If the City Council decides not to award to the lowest bidder, or some disqualifying reason, notice must be provided to all bidders, and they must be allowed to comment upon the basis for choice of other than the lowest bidder. Legal counsel should be involved in each one of these circumstances. Specifications should define both quantity and quality of service. Contract terms should be spelled out either in full or at least in large part in the bid process. That will help avoid remorse in the aftermath. Do not just borrow specifications from your neighboring jurisdiction without evaluating whether they will meet your needs for the services to be bid. There are two primary exceptions to the bidding rule for services that exceed $25,000 in cost. Recall that services under $25,000 can be purchased in the open market based upon a straightforward assessment of value. The primary exceptions are personal services and professional services. Neither of those services are required to be purchased from the lowest cost provider. Personal services are those that are provided by someone who has unique abilities as a service provider. Examples might include insurance brokerage services, real estate services, computer programming, or the like. The demonstrated abilities of an individual can often determine the value of the service. Perhaps the distinguishing feature may be experience programming a computer in certain subject areas, addressing a certain type of computer equipment, or using certain computer programming languages. Personal skills, access to particular markets, or other unique characteristics distinguish one service provider from another. In those instances, you need not take the lowest price, but rather contract for the most suitable service. Likewise, in the professional services category, price doesn't determine the service provider. The purchase of service by lawyers, physicians, planners, etc. need not be procured solely on the basis of price. In other words, you need not have your brain surgery performed by the low bidder. There are, in some instances, additional requirements for professional services, particularly those provided by design professionals. An additional video training session will be provided for procurement of professional design services, which is a unique category of its own. Those design services include services by architects, engineers, landscape architects, construction managers, and land surveyors. The keys to successful service procurement include avoiding dividing service purchases to avoid bidding. Remember to tabulate the annual costs. To write specifications that are clear and unambiguous so they can be part of an effective service contract. And to follow the administrative requirements established by law. If you must bid, you must take the lowest price from a qualifying bidder. For professional design services, remember the special procedures that govern such purchases. Thank you for joining us about this subject. Remember the link to ask questions, and remember that answers will be returned on this website at some day in the future. Thank you for joining us.